Hi, good afternoon, everyone. Can you hear me? My name is Cheryl Harris. For those of you who don't know me, I'm a professor here at the law school, and I'm affiliated with the Critical Race Studies program. I really want to welcome you all here and thank you all for coming to really this very important event. I'm going to make a few introductory remarks and then turn it over to my colleague Ariela Gross and our guest, Professor Patricia Williams. I want to start by saying that something about the official and considerably amazing resume of Professor Williams. She is the University Distinguished Professor of Law and Humanities at Northeastern University School of Law, holding a joint appointment with the Department of Philosophy and Religion, and she is director of the Law, Technology, and Ethics Initiatives in the School of Law and School of Social Sciences. She's a former MacArthur Fellow and has held numerous fellowships, prestigious fellowships in many universities, many numerous awards for her work. It's also true that many years ago, Pat and I attended the same undergraduate university, Wellesley College, as part of a small cohort of Black women students at a time of monumental social change and protest. We were all trying to find our way, both individually and collectively, and find our voices. Pat's quiet fire, her intense observational skills were obvious then. What was not so obvious, at least not to me, in my own fraught dance and engagement with the rarefied air of the place, I don't know how many of you have ever been to Wellesley, Massachusetts, but it's quite rarefied, was how extraordinary her voice was and would become. And if one were to list all the articles, essays, books, and other things, it would run into the hundreds of pages. Yet to list them all would really not convey her import as a scholar and the generative power of her work. It really comes into focus when considering it in an entirety. It's really dazzling in its variety in form and subject matter. She is a lucid and lyrical writer who crosses disciplinary boundaries consistently, deploying insights from legal doctrine, critical theory, political philosophy, literature, cultural studies, humanities, and histories through a range of autobiographical essays, books, and political analysis, and her unique form that blends all of these. Her distinctive voice is grounded in theoretical sophistication as well as her uncanny ability to weave connections to the ordinary that are both compelling and revelatory. Some of you may have encountered The Alchemy of Race and Rights, however many some of you have, so you know what I'm speaking about. It's perhaps among her most well-known and celebrated works. Published in 1991, it's been described as a feminist classic, one of the 10 best nonfiction books of the decade, and it remains of singular importance in both form and substance. Utilizing the form of a diary, a form of writing traditionally associated with self-exploration, she transformed it into a text of communal self-reflection about the nature of ordinary racism in all its quotidian dimensions. Central to Alchemy is the tie between the everyday experience associated with Black life and the structures which reify and legitimate that subordination. Her work disrupts the normalization of practices like the special racial scrutiny attached to navigating the public sphere, and challenges the notion that racism is only the practice of the intentional bigot. I could go on to talk about the individual chapters of this book, but I guess what I would really just want to close by saying, because really we're here to hear her, not me, is that one of the things that's really powerful about Pat's work is her constant ability to find surprising connections. And I think in this most recent book, we look forward to her continued sort of brilliant insights in helping us understand the everyday in the ways in which it is connected to the extraordinary. So with that, I'm going to turn it over to Professor Ariela Gross for her conversation with Pat, and I look forward to your questions, which I hope you will have many. Thank you.
Thank you so much, Cheryl, for the starting us off and for the reminiscences. And I also want to indulge in a little reminiscing. I just want to, start by saying what an incredible privilege it is to be in conversation with you. I first also encountered Pat Williams through your work through. Is it on? No? We heard they were live.
It sounds like it is now.
Yes?
Yeah.
Okay. I'll bring it closer. Also through Alchemy of Race and Rights, which I read in the summer after my first year of law school, where I was looking for the antidote to the first year of law school, and I found in that book really a different way of thinking and approaching law from what I'd gotten in 1L, and it was invaluable to me for the rest of my studies and ever since. And then when I was a 3L, I was also a graduate fellow at the Stanford Humanities Center. And when some of us fellows discovered that the great Pat Williams was also a fellow at the other Stanford Center for Advanced Study, we thought, what if we invite her to lunch? Would she come? Do you think she'd come? And not only did she come to lunch, but turned out to be such an incredibly generous scholar and mentor and role model. I felt very, very lucky ever since. So it was with excitement that I approached new book, this incredible cover, The Miracle of the Black Leg. And my first question is kind of a long one, more of a commentary, then we can get into it. But you open the book with the case of Wood versus Wisnant, this bizarre case where John Wood's leg was amputated after a plane crash. He keeps his embalmed leg in a storage unit, so eventually he could be buried whole. But when he falls behind on rental payments, the contents of the storage unit are sold at auction to Shannon Wisnant, who finds the leg. And now you have this legal dispute where Wood says, it's my leg, it's part of my body, and Wisnant says it's my leg because I bought it. And so you set up this unbelievable, well, is this part of the body alienable in contract, right? Or does it fall within the realm of what we deem inalienable under the Constitution? And it sets up what I thought was a fascinating contrast that keeps going through the book between contract law, which you say, quote, concerns itself almost exclusively with the interests of private parties who assign value to the object of their contract according to their own subjective sense of worth, and then constitutional law, which governs the realm of polity, civic life, and civil rights. So under contract law, Wood's leg is just a thing. Under constitutional law, the leg may be seen as an extension, you say, of Wood's dignitarian interest in the integrity of his body, autonomy of mind, and general civic regard. And then another place you contrast, and I thought that was an incredible phrase, the vivacity of righted humanity, that's constitutional law, with the civil death of objectification, and that's contract law, and then say this distinction is at the heart of the legacy of slavery, right? That contrast between objectification and humanity that's at the heart of what it meant to be a slave and the legacy of enslavement. And that really stayed with me. It was incredibly provocative, both because I teach both contract law and constitutional law. and because I've been thinking so much about slavery's legacies in constitutional law or our constitutional memory of slavery. And what I kept thinking was, given the relentless efforts of this Supreme Court to erase slavery and slavery's legacies from our memory, and from the law, from constitutional law, to deny the vivacity of righted humanity, and our dignitarian interests and the integrity of our bodies, especially women's bodies. What's left? What's left of the distinction, right? What is this, are we upholding a constitutional law that we're just dreaming about now, aspiring to? If it's gone for the foreseeable future, are we better off with just contract? I guess I wanted to ask you to reflect on this dichotomy between contract and constitutional law in the world of constitutional law we now, unfortunately, are living in.
Okay, that is quite a question, but let me just start by saying that, first of all, I just want to thank the two interlocutors. Cheryl Harris goes all the way back to undergraduate. Your presence when you burst through that door at Stanford, really, and your work has so influenced my own. And it's influenced it precisely through this, the capture of the tension between constitutional and contract law. And I have, ever since I took a look at your research, I have been influenced by it absolutely ever since. So let me answer it through the influence of your work on my own. I think that you asked whether there is any difference. I think that there's absolutely a difference in when we study constitutional law and when we study contract. I do think there's been a sort of bad faith attempt to take what used to be unequivocally the subject of civil rights and push them into the arena of private law. So in that sense, it's simply that the location of the claims that we're considering has been moved or excavated from what we consider constitutional law and into contract. Then the second dimension of this distinction or tension between constitutional law and contract law, I think, has to do with not just the tension, the doctrinal tension, or the ideological tension. There's also something that is almost magical about that vivacity that I was trying to express. The reason I used this particular picture to frame the book, which has nothing to do with contract, constitution, or anything modern, quite frankly. It's a Renaissance picture that a student brought me in 2018, and it's called The Miracle of the Black Leg. I didn't make up that title. And there's apparently a whole series of paintings from the iconography of the Renaissance involving the twin Catholic saints of Cosmas and Damian. They're not mentioned much in the Italian church anymore, the Roman Catholic Church anymore, but they're certainly revered still in the Eastern and Greek Orthodox Church. But this picture intrigued me so much because instead of just looking at it as something from the Renaissance and placing it in that cultural context, I'm a product of this culture. And I looked and I saw a hierarchy painted in this arrangement, in the very composition, that there were these saints and the top of the painting is cut off, but there is a flow of color, and color is highly representative in Renaissance paintings. And there's a flow of what seems to be the blood and the vivacity of Christ that comes from literally over the twin saints. It flows through the middle of the picture, through the blanket over the white body, and it ends where most people miss it because it's a duller red, which is the body of a black man missing a leg. Clearly that missing leg is attached to the white body. And so it stated a kind of hierarchy which is expressed through at least color representation, if not anything that resembled the way in which we talk about race today. That concept of race clearly wasn't in existence at the time, or maybe it was in its very nascent stages, or maybe some ancient reference. But it struck me, and from what little I've been able to learn of the history of this painting, it appears that the man on the bed is either the Emperor Justinian or a pope of some sort, and the body from whom the leg was taken. Yesterday, some people were at USC. People were saying, "Well, was there a donation of that leg?" Let's just say the leg was detached. It was attached someplace else. Whatever meaning that has is lost to historical specificity. But the relationship signified something that allowed me to wander, and my first association in that wandering was Frederick Douglass's description of when he fled his master or ran away from his owner, so-called. He characterized it as a theft of his leg and a theft of his arm and a theft of his hand and a theft of his heart. In taking his body, in the autonomous exercise of removing himself and walking away, it was also a theft of property. And that complicated relationship, which challenges the autonomy, the civil existence of that body in the vice of contract understanding, is something that, again, I think has, again, not just a doctrinal aura. There's something magical about it. There's something magical about the way in which we value bodies, or something, if not magical, then miraculous, or there's a miracle to who we are, and there's a way in which that miraculous quality of our humanity and our vibrancy and our encounter interpersonally is confined or expanded by the mere language. And so then I started looking at the language of contract and how that differs from the discourse of constitution. And Ariela laid out some of the differences: the integrity of the body, the pricelessness of the body when we talk about the constitutional composition of ourselves. But when it's in contract, everything has a price, and that price is a kind of currency, which means to say that it can be anything. It can be zero. You can throw away your property, you can throw it off a cliff, and it's up to the private owner of that property to fix a price on it, to make it valuable or not. And that particular system of value is baked into American law at a very particular moment. What we have a system of contract that began, or since the first restatement, the second restatement, whatever we have now, what's left of contract. We forget that prior to what we now call the will theory of contract, which is the consideration, literally what we consider as value, as the object, and how we are valuing the object of contract, is the expression of the will of either the offerer and the acceptor. But what the system that preceded that was a so-called sound price theory of contract. And so the law put guardrails. You could, in contract, really you can value anything, and unless it contravenes some great public interest, contract gets enforced as long as the two parties did so of their own free will. The system that preceded it said that no, if you're selling a pig or you're selling a cow, you can't place a value of nearly nothing on that. That the price has to be sound as determined by some community interest. And so that putting forth of a normative value, a baseline of normative respect, was a kind of ecological interest. It was a kind of anti-throwaway interest, that you couldn't just drive it off a cliff, or that there was something that individual private owners couldn't simply smash to pieces without there being at least a social understanding that violated the inherency of things. And I think that to discuss that as a kind of inherency of value, particularly when contract is applied to living creatures, or not creatures, doesn't have to be full mammalian bodies, but just that's why I say it's sort of ecological, things that depend upon it, that are interconnected in that sense of value, is a really important dimension of contract that I think we've lost. And I think it was lost particularly by the discourse of how slave law and agricultural law really diminished the presence of that lively essence. And so I think I encountered Ariela just as I was writing about the very first surrogacy case, the Baby M case. I'm sorry, I have terrible allergies, and so you'll hear me. I'm sort of speaking through my congestion, forgive me. So I really encountered the Baby M case and looked at that contract and recognized that the lawyers in the Baby M case, having no precedent for that kind of new biotechnology, literally reached into their drawer and they took an agricultural contract. And I was teaching at the University of Wisconsin. I was teaching bovine and porcine law. I was teaching the law of sales of animals. But it turns out that that law literally came in through the civil law as a form of, as a series of contracts that also applied to slave bodies. So suddenly I was looking at slave contract, which had been outlawed in the United States, but carried on in terms of the discourse and the relationships to the object of contract through the way in which we buy and sell animals and our food, as well as other things like plants and all kinds of things. And so that this is in the Baby M case, it started to be reapplied to human bodies, and then even more over the years, it became applied to things like human cells, living cells. Chakraborty, the Diamond v. Chakraborty, one of the early cases of the sales of life forms of cells. And now you see this really creating ethical problems in fairly confrontational ways in the sale of embryos and forms of IVF technology. And in fact, in Virginia, there's an IVF case that actually cited an 1839 slave law case, and that's in the book as well. So that literally talks about slave bodies being a kind of personal property, and they said, of course, we're not analogizing this to slavery, but the life can be the object of sales. And I think during the Industrial Revolution, our contract made this transformation that did away with sound price theory, made it the exclusive category of choice and will of the transactors over the object of contract. And contract is a lovely, elegant system of exchange as long as you're dealing with nuts and bolts or a batch of blue jeans. It is much crueler when you're applying that to the fate of things which have a kind of mortality to them, or an exhaustion point to them. So, I'm sorry, that was a long question, but I had an even longer answer.
That was great. And the essay on being the object of property, right? That was one of, I think, the most, I found the most moving and influential, but one that I think is one of the best known as well of your writing.
That was the starting point of Alchemy of Race and Rights. It's the last chapter in Alchemy, but it was actually the first thing I wrote, and the entire rest of the book came around that. And for those of you who have not read it, it's the story of my sister finding, about the same time of the surrogacy contract, my sister going to the National Archives and finding what we think is the contract of sale of my great-great-grandmother. And so it was this really jarring, transformational moment. I mean, up until then, I had been writing about, lien equity law and the Uniform Commercial Code, and all of a sudden everything became not just personal but about bodies in a way that says, what are the limits of these kinds of transactions over bodies? What is the outcome? And not just for those objects, but for how we use words to devivify, to make. So civil death took on a very material meaning for me after that point. Yeah.
So I kept thinking of when in this book, when you write about Douglas stealing himself and talking about the theft of his own physical body, I kept thinking about right now, this moment with Haitian immigrants being, the blood libels that being spread about Haitian immigrants, and that Haitians, Haiti had to pay and is still paying the debt of stealing themselves, right? Haiti, the first nation to find independence through a revolt against enslavement, owed compensation to France for the human beings who stole themselves. The property that they took from their owners in becoming free and self-emancipation was a debt. That's the original debt of Haiti to the foreign nations. And whenever I think about, all of these crazy stories and libels slander against Haitians, it all goes back to that original theft, that reimagination of the revolution as a theft of their human property. And I wanted also to talk about, so you brought up Baby M, and the case that you talk about in this book about the commodification of human beings and birth and wrongful birth is another unbelievable case about where a white family sues a sperm bank for having had a black child, and not only for the harm to them, but apparently also for the harm to the child that you talked about.
Well, it's an interesting inversion of the what could be a civil rights case, and I think that, but it is a perfect example of what happens when you take the concept of civil rights, you lose a sense of what the civil rights are actually doing to real human beings. And if you think entirely in a contractarian universe, then this child is treated and talked about as a commodity. So this was a case in which the sperm was accidentally mixed up. They had chosen, the ideal Aryan sperm, the promise, these guarantees of a particular life form is going to come out. I mean, I can say a lot about my concern about the way in which people are choosing, designer babies and so forth, and the, in fact, I just had a piece in Los Angeles Review of Books about that just came out yesterday. For those of you who are interested in my very opinionated opinions on this subject, of the way in which people purchase attributes through this kind of embryo selection and test them for particular outcomes, and treat it not just as a medical concern, but as a kind of guaranteed outcome of contract. And so there's a breach of contract if the child, ultimately comes out sulky and a delinquent, I think. And I'm sort of joking here, but at the same time, this child came out visibly African American, as they said, and they sued not just for breach of promise with regard to that they had not delivered the sperm that they had promised to, which is a kind of tort having to do with the duty of care in the handling of the genetic material. That's another kind of case, and I could say something about that's not what I was writing about and what I objected to. What they sued for, in addition, was wrongful birth. That this child is visibly African American, and this is something that the parents were totally unprepared for. As part of the claim, the mother says, I have never even encountered a black person until I hit college. And so it's a very steep learning curve, and so I need to be reimbursed for the extra expense of having to teach myself, I guess, or having, to compensate, which is we need psychological assist now. This child will be going to an all-white school, and I keep wanting to say, well, formerly all-white school. And it's interrupted our family relations because our family could hardly stand that we're gay, and now this. I mean, this is literally what they said. And I looked at this and I said, well, and they had to travel so far just to get her hair cut. I mean, everything was a crisis. And they wanted reimbursement for this in contract terms. And you look at it and you say, well, this is what affirmative action was supposed to address. But at a societal level, this is a problem with society. It's not a problem with a breach of a contract. This is not a problem with the child. The child was perfectly healthy as a human being. This is a problem of a broken society, and this is a disappointment coming with the broken promise of civil rights and the notion of equality. And the idea that you are going to make each one of the complaints based on this breach a privatized remedial system. I mean, these parents, white though they be, were in no different position than any black parent trying to raise a black child in this world. All of us, everybody who is a black parent, or the parent of a black child, or a white parent of a black child, or of a minority or a marked container, whether it has to do with race or some other object of bullying in our society, faces the difficulty of getting the haircut, finding a house, finding a school, being treated, or being ejected from certain social groups. And that seems to me is precisely what civil rights claims are all about. And so to put it all in the contract, or in the realm of contract, may give them a certain claim for having to find a school that's more integrated. But it doesn't fix the larger problem. It doesn't make it go away, and it privatizes it in a way that ultimately ends up in the resegregation of our society. I mean, it's almost a license to resegregate.
That was an amazing case, but I think one that really kind of highlights that contrast that you've drawn and how we're trying to take all these cases out of, and a kind of individualization or privatization we're seeing in so many realms. Let's take this out of finding a structural solution, and let's see if we can make this think of this as only an individual problem or only the problem of the victim who needs to fit. So I wanted to ask you about as we're here in the critical race studies program, and as one of the first generation of people working in critical race theory, both how you see what's happening now, and maybe ask you to comment on how you see it looking backward. Because at one point you say, I've always thought of what Bell started as a critical race conversation rather than a theory. And it was a time of great transformation, a productive, hopeful, even joyful time. And, and I know for me it was that experience when I first read your work and other early, I came into law school pretty soon after Kim Crenshaw's first big piece came came out, and I'm reading all these things kind of right at that moment, when it really does feel like this conversation between critical legal studies and critical race theory and feminism, and just this very active moment of this conversation. And now here we are, where you have people like Christopher Rufo saying, I get to define what critical race theory is, and as you say, they've transformed it into an emotional repository, a well-spun sorcery, a haze of hate. It's an effigy. It's whatever makes people feel guilty, shamed, or blamed. It's sort of hard to recognize, in how it's appeared in this new public discourse. But I just thought we might.
Well, I mean, it's in such bad faith. So, critical race theory was always gently, it was. I viewed it as a sort of gentle awning over a group of scholars who may or may not have had a lot in common, and that's the only point that I'm making about theoretical. It was not particularly theoretical in terms of how my work relates to, Kim's work or Cheryl's work or all of us who are under this loose umbrella. But it was a loose, friendly umbrella, and I think that the thing that many of us had in common is that we were students or readers of people like Derek Bell. But Derek Bell was very different from the other umbrella under which so many of us fell, which was that we were loosely associated with the so-called crits, who were much more controversial than critical race theory at the very beginning. That was Duncan Kennedy, Roberto Unger, sort of the Harvard guys who were very much in conversation with each other. We're having a conversation of the rubric to a great degree, and I think that's where the theory comes from. They were Frankfurt School thinkers. Frankfurt School, they were heavily influenced by that, and but it was this diffuse wondering and it was marked by those of us who had these professors at a particular moment when law was transforming, in the wake of the civil rights movement, in the wake of new laws, in the wake of a consumer movement. There were just a lot happening in the wake of the feminist movement led by, Gloria Steinem. I mean, I am of a generation. I am, I was in Mitt Romney's class in law school. And, and women were 8% of the class. And even though Ruth Bader Ginsburg was much older than I, it hadn't changed much, except there were a few more women in the class. But still...
Binders full of them.
But exactly, when he made that comment about he was looking for binders of women when he was running, I said, poor Mitt, I know exactly what he means, because I come from the day in which all of us women were enclosed in binders. There were very few, and you had to look through to try to find out who are the women here again, and where are they? And in which I was the last class in which they actually had at Harvard Law School what they called powder puff days. They would call on women once a month, and then they would throw us powder puff questions, which is to say they were light and fluffy. And everybody got to laugh. But that was their way of suddenly becoming gentlemen to these new ladies who were just basically the objects of some kind of scorn. And, my class ended that practice, let's put it that way. Ended that practice. But in that time, the women, and then there were, even fewer people of color. I think there were, I don't recall, I think there were 2 what were then called Hispanic, undistinguished in terms of any other ethnic origin, men in my class. There were almost zero Asians of any kind, South Asian, East Asian, anything, except for international students who were nationals of largely Japan and so this was a very, if you ever see the film 1L, that was filmed while I was still in law school, and we were still kind of, they diversified it more for that movie because there were more women in that depiction. But in fact, I was in a scene in which I was coming off an elevator and I waved at the camera and they cut it. But at any rate, but that's the time I was in law school. It was almost exclusively male. All of my professors, except for Duncan Kennedy, looked like Professor Kingsfield and acted like it. And it was a way of, and everybody talked about vegetarian as opposed to red meat eater. And red meat eaters were the winners in the classroom dynamics, and the vegetarians would be, their wilty little leaves would be devoured and trampled over. So that was my law school experience. And the conversation that came out of it was a surprise to many of the people in the class. In those times of experienced segregation for everybody, not just the people of color, not just the women, but the men in the class, when we started talking about Williams versus Walker Thomas, it was a black student who raised her hand and said, because remember, Williams versus Walker Thomas never mentioned race, but the black students recognized, well, the reason that the white students could say, well, Mrs. Williams was just a stupid negotiator. She was, she made a lousy choice, and therefore she has to be held to the consequences. It was the black students who said, no, that's a ghetto practice. This is a racialized case, even without, you just know that the reason she looks like a stupid transactor is that you're not looking at this as a pattern and practice in certain neighborhoods that may be invisible to you. And when you took a look at that, then it became one of the early consumer protection cases as well. Not that anybody acted on that insight, but that's, so those were the conversations people were having. And remember, early critical race theory was also perceived as a very integrated. I mean, there were white people associated with critical race theory, like you, and so that's the reality of critical race theory. And some of us are more associated with law and literature than critical race theory. I mean, there are overlapping movements, always in law, depending upon what's happening in current events. I view critical race theory as one of those movements, interest groups. Interest group might be a better, and scholarship. So what is it now? It's been condensed into something that's hard-edged, that involves any black scholar writing about blackness. It doesn't seem to be an attack against white scholars writing about blackness. I mean, I don't know if that's your experience, but certainly among other people, I don't see it. And the degree to which it has much in common with feminism, with other kinds of human rights that have been infused with, or ethnic studies, for example, or the status of latcrit. The use of the term critical race theory as it's become a legislative item, as that which, as Donald Trump said, must be extinguished because it is poison in our system, in that fascistic object of extermination, you get this language of extermination, is the product of the Manhattan Institute, the Heritage Foundation, of right-wing scholars who seem to be bringing back something like, the Confederacy through this language. And you mentioned the Elders of Zion. I mean, the Elders of Zion began as a rumor that became real to huge parts of the global population in today's world. And I am very worried that this kind of purposeful introduction of hate combined with the other elements of what it takes to make a people more easily the object of genocide or of violence or of enslavement ultimately involves using, language that dehumanizes. uses language that associates populations with contagion and disease, uses populations to be designated as beyond the pale and designated as those who are sources of pollution for purposes of both territorial invasion and blood corruption. And so listening, it feels like we have crossed a whole bunch of new thresholds since 2020, not just the attack on critical race theory, but even in the last year, the explicit language that Goebbels used, the explicit language that Victor Klemperer writes about in his diary of the lead up to the exterminations of the Nazis. This vocabulary is borrowed sentence for sentence in some of the expositions that I'm hearing now, and it's scary. It's scaring me. So my concern is not just critical race theory. It is for the safety of anybody who's marked in these terms, and it isn't just critical race theory. Any group can be sort of expropriated from the way in which they express themselves. If you have enough power and particularly in a technological age, you have enough control of outlets. And there's just a huge amount of money behind this to change legislatures, to attack libraries. I'm sorry, it was a long-winded.
Oh, no. I mean, there are two aspects that you talk about in the book that I think I respond to, and one I think does sort of apply across the board. You asked, do you see this as do I experience it as a white scholar? And I think the aspect that I do is the aspect that you talked about as erasure. That is, we want to erase this history, and we want to erase everyone who's trying to write that history. We want to erase it. We want to erase that from curricula. We want to ban it from libraries. We want that kind of erasure. But then there's the other political move, which was from CRT to DEI, right? And which is a very cynical, planned move with all the money behind it that you're talking about. And that is about directly attacking the people and the bodies of the people who are the scholars or anyone who is doing a certain job. I just wanted to, while we have a few minutes left, give our audience and our students a chance to ask questions if there are people who want to. Don't be shy. Yes, in the front.
Hi, Professor. Last time I saw you was we did a virtual colloquium with Professor Deborah Turkheimer.
Oh, that was a while ago.
That was a while ago, yeah.
Yeah.
I asked you then about how we can get to burning it down or whatever. I was very different back then, and my thinking has evolved as well.
Even in law school.
Yeah, it was a while. But I think my question now is, well, one, thank you so much. It's always great to see you when you talk. But my question is, how do we get to building something up, I guess, and what principles do we build upon? And are those principles maybe constitutional law, contractual, or maybe even religious principles?
I mean, I think that based on the last part of what Ariela was asking me, I do want to make a distinction. I feel like all my writing is about what do we build on. And that's important to have a set of principles, a set of ethical guidelines, a set of what is the appropriate realm of contract, what is the appropriate realm of this. I work within a structure as a lawyer that I learned in law school. I try to apply it as expansively and as inclusively as I can. If you ask, what do we do right now? It feels like it doesn't matter what I say. I mean, that's really what is scaring me about this moment. It doesn't matter what comes out of my mouth. It's like, I'm like the Haitians, or we are all like the Haitians in Springfield, Ohio. it doesn't matter because you're not part of the American people that J.D. Vance is trying to speak to. And therefore, there's been a political turn to this moment in which the question is, do you run for your life because you've been objectified and people are following a fantasy that you are the poison and the threat to the American people, even when you are, you've done everything right. You're legally here. You haven't eaten cats. You've returned the pets that wandered across your. It doesn't matter. You've been characterized in a way and in a bubble that is very hard to break through. And I don't have a good answer for that. And I don't have a good answer for that in a country that's as well armed as we are, and that's as on edge, and who are courting in the kind of political power that individuals can't respond to. So I can state my principles all I like, but if nobody reads them, and if nobody hears them, or if you say something and they say, well, what you say actually means the exact opposite of what you're saying. It's a definitional treadmill. And that's why I mentioned Victor Klemperer a few minutes ago. He was a linguist who lived in Germany. He married an Aryan, which is how he sort of hid himself into safety. But he follows how the German language changed leading up to the Third Reich. And there's this sentence that really echoes to me what's going on now, in which he said he was a teacher in the university, taught linguistics in Austria, and there was a moment in which all of a sudden, not only were they taking the books off the shelves, not only didn't want people writing about Jewish history or anything, they were taking all the books written in Hebrew off the shelves. But also, it was when somebody turned to him and said, "Who are you to teach us anything, no matter what you write? Who are you to teach us anything?" And he pinpoints that that is the moment when you went from what scholars of genocide have called not just the norming of violent language, but to action-inducing language. And it feels to me that what's happened, particularly just in the last few months, is this kind of almost permission for action-inducing based on lies, fabulists, propagandists, and it's Orwellian. We really are in a moment where, 4 legs is good, but 2 legs is even better. And people are nodding along. Yes, that's right. And I don't know. I'm very open to suggestion. I don't know what to do about this moment, except to broadcast my concern about it. And this is not stuff I've written about, but, Victor Klemperer has and he says, what happened in Germany was not being hit over the head. He said it was like 1,000 mosquito bites over time. And it feels like, we've had our 1,000 mosquito bites and now the blood is starting to drain and we're getting weaker and more normed into this sort of fascistic moment. So that's what worries me. So I recommend people read people like Lynn Terrell, who is a philosopher at University of Connecticut. And she's written a piece called Genocidal Language Games. And she lists the steps of what it takes to bring people to the point of violence. The object of her study is Rwanda, but it's quite applicable and in accord with people like Victoria Norris and other people who've written about what leads to a kind of progression of the kind of genocide, the moment when you go over the cliff and you can't retreat.
And you may know Jason Stanley's book also, How Fascism Works, and his new book is called Erasing History, because, of course, that's a piece of it, right? All of these laws of all the book banning and the laws against.
And Nathan Crick has written a book on fascism. There are lots of books on this, but it feels like that's a discipline and an area study that I didn't bargain for in the beginning of this.
Yeah, Lenore.
I had a question talking about you bringing up the DEI attacks that have been happening, blatantly racist attacks on diversity, especially in the workplace. And I was thinking this term DEI hire that's being thrown out as an insult it kind of relates back to what you were saying about this objectification within contract, signify that black employees are worth less. And I think this is, I just want to get your take on whether this attack is being thrown out purposely because we are so used to employment and labor already assigning worth to people, already assigning this objectification of people, that it's so much easier to do this blatant racist attack in terms of employment because we can clearly assign worth, and that's where it sense. Like, how does that relate to this contract objectification?
Well, it certainly is employment, but it's actually against every area of civil rights progress since 1963, as far as I can tell. They're leaving very few. It's voting rights. It's, it's schooling. This feels very broad in its attack. So I think what unites it, and looking at some of the people associated with this, are people like Charles Murray, who basically says they're not as good. I mean, let's just look at the fact that blacks are not equal to whites, that their IQ scores are lower, and yes, absolutely, you should treat them nicely, and it may be that your child is in school with a kid who beats all of the white kids because she's so smart, but let's recognize that for the exception that it is. And policymakers need to stop feeling so guilty about this. And you can read Project 2025, or you can look up Charles Murray's work, his last book, Facing Reality. What?
Or Amy Wax.
Amy Wax, yeah. But for Charles Murray in particular, in his last book, Facing Reality, is very, it's a book precisely about the eugenic history of let's just treat blacks as lesser. And just don't use the words. I mean, he is the Lee Atwater of this generation, but and I don't know if, is Amy Wax also associated with Project 25?
I don't know that she's directly cited, but she's carved out an area of scholarship based on articulating black intellectual inferiority.
Right. No, she is, but the real power, the push, she's been doing that for a long time. Yeah. But the real power of this moment and of Project 25 is Charles Murray, who is part of 2025. Yeah.
It also makes me think, one of the things that you talk about in the book is the bizarreness of this moment that is supposedly post-racial, colorblind. We have this whole jurisprudence of colorblindness saying that race doesn't exist anymore, that we don't even see race. That's awash in this, explicit racial assumptions. You have this reinstantiation through DNA and DNA testing, and
yeah, absolutely. And that's the other part of this, which is that I think that there's a religious undercurrent to the assertions of blood hierarchy that is linked to, and I remember having a debate in the 1992 Republican Convention. I actually went to debate on behalf of the nation Ralph Reed, who was then head of the Christian Coalition, and he laid it out. And it was scary. I mean, it was also Newt Gingrich and all of that. But he specifically, and I view this moment as Bob Jones University's revenge. Bob Jones University was the case that literally took the federal funding from a university which explicitly was racial, based on, we're not going to do intermarriage, we're not going to do whatever. And they are using the same language of attack against places like Harvard. We're going to take all your funding right down. We're going to, expend, or we're going to empty your endowment based on your lack of diversity, your reverse racism. So they've literally reversed every single term. And there's a cheat sheet being circulated by the National Association of Scholars, which takes every word from the civil rights canon and says, social justice, what they really mean is social injustice. Equity, what they really mean is inequality. It does the Orwellian reversal of everything, and they send this to every state legislature, every school board throughout the country. And so it's this teaching that when you hear these words, which are supposedly words of liberation, you're actually hearing, the baying of hell's hounds. And so that's what I mean by it's a strong, well underwritten attempt to to create a series of associations. It's almost, they will attack critical race theory for being too Foucaultian. Maybe we cite Foucault too often, but I really do think that there's a paragraph that at the beginning of Foucault's Order of Things, in which he talks about Borges's invocation of a cabinet of curiosities, in which there are all kinds of just weird things, and they're all put into one paragraph. And they have nothing to do with one another if you took each individually, but when you put them together, it is literally the proximity of extremes that makes them become associative or weird kinds of equivalences. And that seems to me, and he's talking about not just the order of things, but also the power of propaganda and the ability to change language, and that's what we're facing now, an extraordinary sophisticated propagandistic intervention here, and the sort of religious equivalence of white as associated with something that is God-given and that almost is associated with the religious mission, I think cannot also be understated or underestimated in what's at stake in this election. The final thing I'll just say is that we talk about white genocide in this country. There are a number of people in Congress who've talked about that, but we're not making the right links in terms of the global attack that's occurring. For example, in Europe, under the rubric of what's called the Great Replacement Theory, another linguist, Renaud Camus, who is a Frenchman who has written this book called, it started as a lecture that he gave in 2010 about the Great Replacement, in which he takes of all texts Frantz Fanon's ideology and says he was a great guy, because it's true. We French were invaders to indigenous Algerians, but now it's the Algerians who are the new invaders, and we white French, particularly the Franco-Prussian line of the sort of second estate as opposed to the feudal third estate, but the second estate are, they're under attack. And that's a whole reference to, older eugenicists like Gobineau, who basically asserted, he was so sorry to see the French Revolution succeed because it displaced the nobility, who actually were the blood-lined people who were closer to Aryans. Gobineau's work is where Hitler got the reference to Aryan, because, and so you have this man who is reasserting this in vocabulary that is well worth deconstructing for its historical precedents, and it's very much the language of the French far right, the right that is even farther than Marine Le Pen and her father and so forth. But I do worry that it is becoming a global movement, and that's why Viktor Orban is so important. It's why Steve Bannon is so important. He spends a lot of time setting up a new sort of foundation and think tank I think it's based in the Netherlands or in Belgium, that will do this work combining sort of American fears and European fears.
Viktor Orban respects Trump very much.
I know. Well, and you see the line right there, but take a gander through Renaud Camus' work. Not to read it for its own sake, Xerox copies so that you don't have to put money in his pocket. Sorry. But it is available in English, I think. But it's if you read French, it's good to read because he does all of the same reversals that the Manhattan Institute is doing through the voice of somebody like Christopher Rufo. So this is not an isolated or even American product. It's laid upon individual culture's history of anti-Semitism in Europe, of anti-Roma feeling in Europe, of fear of Algerians and Moroccans. I mean, there are a whole bunch of us who are in this together, and we better see the potential coalitions and the way in which this is about marking and drawing boundaries, regardless of who you are.
I think we have time for one more. Yeah.
Hello, Professor.
can even postpone it till after graduation. I understand.
Well, I can't help but notice the key words of miracle and spirit entitled to this text. And these two key words and concepts come to mind, notions, discourses of religiousness. And so I am curious as to your choice of entitling this text with what I assume is a rare conjunction of legal studies and like these religious, heavily laden religious concepts of miracle and spirit. And so I'm curious as to what has led to or influenced or moved you into selecting these two concepts to title your text.
Well, this is the cover of a book, and every cover of a book and its subtitles goes to the marketing department. And so, quite frankly, it had more to do with that. But in terms of my influence on this, the reason it's called, I wasn't certain about putting the whole painting on. I'm glad they did. I actually like the way it came out. But the reason the book is framed by this kind of miracle is that I didn't know where this painting came from. And in the beginning, I describe just looking at the painting for a year while I was in sabbatical and wondering what it symbolized. And I couldn't find anybody who knew anything about this. I consulted art historians, I consulted religious historians. Nobody knew anything about it, and which is strange to me still. But in the course of wondering, everything that was happening in the law suddenly became seen through the filter of this peculiar painting. And so I think that a lot of what has happened is because, or what I was writing about, is that I was thinking about this image, and so I was at the same time reading about Jean-Luc Nancy, who wrote an essay called "The Intruder" about his heart transplant. And there's a kind of philosophical but also spiritual dimension that this very generally non-spiritual philosopher brings to the experience of feeling or meditating upon somebody else's heart battering away in his chest. And the way in which those embryos that were taken out of the refrigerator in Alabama, and the judge wrote about this is the work of God. I mean, it's a complete religious text, that opinion, but it also occurs to me that it's very similar to the kind of veneration one brings to the bones of saints. That there's a process of veneration that even if one is approaching this from a secular point of view, much of the description that is on both right and left about survival and the protection of the right to procreate exactly through DNA, and suddenly we are very much back to the genetics of who we are, and assigning meaning to that. Is a kind of it's a refreshing of the language of the body, and a language of inheritance, and a language of genetic inheritance that I think is really freighted. It's really freighted. It's one thing to know, who my great-grandmother was, and whether I am or am not related to somebody for purposes of custody or whatever, but how we make family, it seems to me, is a spiritual dimension that has nothing to do, or little to do, I should say little to do, with the kind of blood emphasis that we are now crafting increasingly into the law. But all of that, I think, has much more to do with what I see as the function of religion. Not that I'm a religious person or assigning religious meaning in the sense of particular sects or whatever. I just mean that it is a discourse of religiosity that can inhabit contract, that can inhabit constitutional law, that can inhabit a judicial opinion. That's what I mean by religious language. It's language that purportedly ties us together, but can also cut us off if we are not part of religion is religere, it's to tie together. But if we're not part of what can be or is desired as being tied together, then you get into the histories of who is beyond the pale, who should be cut off, who is the enemy, who is the demon. And so in that sense, that's what I mean by religion. It's not a call to prayer.
I also, just to, and we need to wrap up, but to me, the spirit of the law made me think about what it is about your incredibly wide-ranging, humanistic, and literary approach to law, which was so different from anything I had encountered, right, as a 1L law student, that is about breathing that spirit back into our human understanding of law as people's lived experiences in legal identities and in their experiences with legal institutions, and bringing that spirit back, so it's not just property law or contract law. It is on being the object of property. It was about what does it mean, right, to be a human being with a spirit in this object relationship, and to bring that to life was what animated, I think, for so many of us, why it's meaningful to do this work. So thank you so much for talking about it.
Such a pleasure. Thank you.